invite Arjun Philip George, Christ University, Pune, Maharashtra, to present Marital Rape in India, Unique Concerns.
Um, Thanks a lot for introducing me. I'm here to present paper on marital rape. This is a concept which is well known to all of us. The reason why I'm presenting a paper on this subject is to share my concerns with regard to the recent judgments of Kerala High Court and Delhi High Court with regard to marital rape, and to bring to your notice a judgment which was passed by Supreme Court in the year 2017, which addressed the exception 2 to section 375, that is exception with regard to marital rape, and which suggested certain amendment to that particular provision. When we are discussing this particular topic, I am pretty sure that even amongst this learned crowd, people might have two different approaches or two different attitude with regard to criminalization, two different opinions with regard to criminalization of marital rape. Now, should this be criminalized, and why, if it should be, what is the reason that it should be criminalized, and what are the concerns which are raised by people who are speaking against the criminalization of marital rape? Now, understand that rape or any other offense that are being particularly directed against women. When I'm saying that rape is an offense that is particularly directed against women, this is the common understanding of the society, that rape can only be committed against women, and women can only be the victim of the offense of rape. It is only because of that social perception that, and because of the topic that I am dealing with, I am particularly addressing the offense of rape that is committed against women. Now, in each of these offenses, we can see that the perception of the offender, the perception of the accused, is that the victim or the prosecutrix is a woman, and I am a man, and I have the right to exercise that power over her. Now, this is the social perception that authority and control shall be enforced over women by using violence as a tool to subordinate them. So they can always be exploited to satisfy the societal norms that are being set by the rule of fathers, or otherwise we will commonly known as we commonly refer to as patriarchy. Now, rape is also as understood by the society, is also a gender-based destructive form of violence. And when it comes to marital rape, understand that it is a most serious form of domestic violence. Now, when we lawyers are studying the provision of section 375, and when we are studying about the constitutionality of exception 2 to section 375, we will be saying that it is based on an intelligible differential, which is permitted under Article 14 of the Constitution. Now, the intelligible differential is you're differentiating between married woman and unmarried. But will a physical offense that is committed against an unmarried woman become no offense once the woman's marital status changed, is a question that we forget to think about at times. This is because of a doctrine called doctrine of curvature that is instilled in each of our mind, according to which a woman is a property of her husband. When we are talking about the provision which was recently held to be unconstitutional in the year 2018 through the case of Joseph Shine versus Union of India, again in that provision, women were considered to be a property. Now, by giving an exception to marital rape under section 375, even the law is trying to establish power and use to and giving legal validity to gender-based form of violence to establish the authority and control of man over woman. Now, this is the famous case, a landmark case, which was delivered by the Kerala High Court. It was a recent judgment, very recent judgment. Now, I couldn't find the citation of the judgment, so I just given the case number. This is not yet reported. Now, this was a case in which the appellant or the person, the husband against whom the case was being filed, subjected the woman to cruelty, not only the physical violence which was committed against her, he forced her to sex when she was sick, when she was bedridden, and on the day when his mother expired. Now, this act was recognized by the court to be acts of sexual perversion. Now, understand that the woman went to family court, that woman went to the family court to seek for a divorce. The family court granted her divorce. Husband went to the high court on appeal. The time that she is spending, the mental effort that she is taking to get justice. The husband went to the high court saying that I am granted exception under section 375, exception number 2. The court said that this exception cannot be a ground for you committing an offense. You have been granted an exception, but it doesn't mean that you can violate the right of another knowingly under that particular exception. And it can be a ground for divorce. It can be covered within the definition of domestic violence. The notion that the body of the wife belongs to the husband is totally wrong, and understand that we all need to understand that sex is something that reflects the intimacy of spouses in a marital relationship, and consent of the wife is very essential. When we are talking about consent in the offense of rape, we always say that even when a woman is a prostitute, we need to take consent of that woman each time when a person is having sex with that woman. Is the status of wife lower than the status of a prostitute, and not grading, not giving ranks to each of these roles? But even when you are recognizing that a prostitute who is doing her work have the dignity or have the right to express her consent or dissent each time when she is entering into an act, why should a wife be denied of her right of bodily integrity? Now, this is the case, 2017 case. I haven't given case in an order because the way in which I wanted to present required a particular order. So I have arranged the cases accordingly. This is a 2017 judgment in which the court clearly said that Section 375 exception 2 needs to be reread as the age should be fixed at 18 and not as 15 as prescribed by the IPC. Because under POCSO Act, a woman, a minor is said to be the victim of a sexual assault, a sexual offense, when because of a minority, just because of a marital status, you are saying that a person has been exempted under Section 375, which is not right. Now, this is a split verdict of Delhi High Court judgment. When one judge observed that exception 2 to Section 375 violates Article 14, the other judge said that it does not violate, and the sex that a person is having with a woman outside marriage cannot be equated with the sex that a person is having with his own wife. Now, why can't this be equated is a logic or standard that is set by the society under the doctrine of coverage. In 1992, in the case R versus R, Justice Lord Keith, he observed that marriage in modern times shall be regarded as partnership of equals and no longer the one which the wife should be considered as a subordinate. Now, we have Law Commission report, Justice Verma Committee report. Now, all these reports are being disregarded when it comes to offense of marital rape. So we should have a right-based approach. Human rights should be the focus of law. Law should have a progressive approach that should be based on the concept of equality. Institutionalized organized violence as a tool for subordination shall never be supported by law. Thank you.
Thank you.